The next item, I would like to make a motion to add to the agenda. Give me a second. Okay. I would like to add resolution 69-14, which I am now distributing to council.
Wait, I'm sorry, who seconded that? Dennis.
Resolution 69-14. We'll have to vote on the addition. Okay.
Vote to amend the agenda.
Okay, addition. Roll call.
Fiorelli?
Aye.
Gelfand? Aye. Goodman? Gray?
Nay.
Ikove?
Nay.
Romeo?
Aye.
Miller?
Aye.
5 ayes, 2 nays.
Okay. Resolution 69-14. I thought about this way more than I probably care to. And Mr. Benjamin, we have a few here. If you want to take them out from. Resolution 69-14. Publicly censoring and admonishing council members Ed Ico and Ruth Gray for violating the rules of the council of the city of South Euclid regarding the confidentiality of discussions held while in executive session and declaring emergency. I move passage.
Mr. Miller, may I give you my statement?
Yes. Go.
I still don't understand. Why, and please someone help me to understand this, because this is what I said at the last council meeting. Why is the hiring of the mayor's son over a year and 9 months ago applicable to pending litigation? This was the question that I raised, and this is the question that I have. Why is the hiring of the mayor's son to the law firm that we have? I'm sorry, because I want people to hear my question, so I'm articulating. Can you hear me?
That's why I'm going to stand up when I do my presentation.
Why is the hire of the mayor's son that happened 1 year and 9 months ago? This is public information. Why was this a part of the discussion in executive session related to pending litigation? That is my question.
Answering that question would put us in violation.
You were in violation, and this
Okay,
is
Ms.
my question.
Gray.
This is my comment. My comment is that according to what I interpret the rules of the Sunshine Law to be, we were in violation when that occurred in that context. Now, whether I'm right or wrong, then the common police court for Cloud County will make that case.
The Secretary of State is the Ohio Attorney General.
I would like 10 minutes without being interrupted.
Let's go.
No, I'm entitled to say before I censor. Yes, I am. I've already been granted leave.
Entitled by what?
By the President of
Go
Council.
ahead.
Thank you very much. Members of Council, there's not a scintilla of evidence that I should be censored for doing anything. As a matter of fact, I'm going to read to you the Ohio Public Records, the Ohio Public Meeting exception. It says, this section shall be liberally construed to require public officials to take official action and conduct all deliberations on official business only in public meetings unless the subject matter is specifically exempted by the law. So it's supposed to be liberally construed the other way. The issue of Miles Wheeler's employment, and I'm more than happy to tell you all this. I love Miles Wheeler. He's a great guy. Georgine is batting 1,000 with her children. I can tell you that for a fact. Miles is a great guy. As a matter of fact, before he worked for Mr. Coyne, he worked for me. How do you like that? And then he went from my law firm, he went to Mr. Coyne's law firm over a year and a half ago. Please, this is not, over a year and a half ago we went. The fact that Midas Wheeler worked for a company that does business with the city means that that's a matter of public interest. Therefore, that discussion should be a public discussion. It should have been disclosed a year and a half ago publicly, if it was going to be disclosed. Mr. Coyne disclosed it 3 days before the executive session by letter to the law director, and that letter was a public record. I asked for it, I got it. Okay? Anybody who wants it can have it. As a matter of fact, we all got it. Therefore, this was not a matter that should have been discussed in executive session. The fact that it was brought up in executive session means that there's called, we learned when we were in the 3rd grade, they're called interlocutory sets. There's one set of stuff that's public, and public information, and the fact that the mayor's son works for a law firm that's done hundreds of thousands of dollars with our city. Not a couple dollars, hundreds of thousands of dollars. In fact, he's here tonight, so we can go into executive session and talk about collective bargaining. But in any event, these are interlocutory sets. So there's stuff that's clearly public, there's stuff that's clearly not public. And these are interlocutory sets. The fact that it was brought up during an executive session doesn't clothe it from not being public. It is clearly public, it's based by public documents. If you go to LinkedIn, anybody subscribe to LinkedIn?
LinkedIn.
Anybody subscribe? Look up Midas Wheeler. He was gay. He was proud and publicly proud to have worked for this firm for a year and a half. So therefore, it's public information. As a matter of fact, I read the article afterwards. I never talked to Sarah Dorn, but I read the article afterwards. The mayor, speaking through the law director, said she was going to make the matter public, but the paper got there beforehand. Well, therefore, the mayor knows it's a matter of public interest, and she was going to disclose it because it was the right thing to do. Unfortunately, she should have disclosed it a year and a half ago. She wanted to publicly disclose it, but she decided to disclose it at that particular time. This is a big mistake, and you all can do what you want to do as far as as far as this is concerned. We all can do what we can do as far as litigation is concerned. I want to tell you, in my tenure on council, I've never seen anything like this before, especially this last minute, superficial way of bringing it out so that we can't discuss this issue publicly and so that the public doesn't have input into this. And that's the reason why legislation is not supposed to be introduced on the floor of council. I don't even know if it's legal to do this at this particular juncture. But it wasn't amended beforehand. It was amended on the floor of council so that people could be not admonished without any evidence. And not only without any evidence about matters that are clearly of public interest. There's no doubt about it. There's not a court in this land who won't say that that's a matter of public interest. Matter of fact, Mr. Coyne himself admitted that in the letter that he wrote. He said this is a matter of public interest, and you guys politically might want to discuss it. And you might want to not use our firm anymore because he's working for us, which is the right thing to do. If you don't, he shouldn't be working for us. He shouldn't be working for us now with collective bargaining. But that's neither here nor there. The fact of the matter is, this is public information. Just because you brought it up during a particular matter of litigation during that doesn't make any difference. It's still public. You can't change the fact that it was public. And a part of due process is that before someone's sanctioned, either civilly or by counsel or by something, you're supposed to know what evidence there is against you before it happens. It's kind of 101 constitutional thing that you learn. And you're entitled not only to know that somebody is, but you're entitled to an adequate opportunity to prepare a case and present that to the body before the vote. Marty knows this. Mike knows it. Anybody who's taken constitutional law knows it. Even if you took it in high school or in college, you would know that that's the basic parameters for it. The reason for it is you have to be able to know what evidence there is, and you have to be able to prepare it. If you can't do that, I'd like to have Sarah Dorn here and have her tell you, David, that despite your innuendos and your inferences and your emotionalism and your drama about this,
Nobody-
there was no, excuse me, don't interrupt.
Don't
I got the
finger
floor,
at me.
counsel.
Don't
I got the
point
floor,
your finger
counsel.
at me.
I'm going to point my finger at you.
Don't
I have the
point your finger
floor.
at me.
There is, I didn't interrupt you. Please don't interrupt. You have not a scintilla evidence, David. And when you talk to Sarah Dorn, you're going to find that out. Somebody's going to talk to her, and you're going to find out what evidence there was or what evidence there wasn't. And you're going to be very, very ashamed. Thank you.
This has nothing to do with, this has to do with, the cliquishness, the animosity. This has very little to do with what is right.
Okay, now we're talking about, well, let me say this and then we'll question. Because someone disagreed with what was discussed and the attorneys that we had said it was appropriate. That was enough for me. So you can say someone's being emotional, I didn't stand up. You can talk about being backdoored. We can go down, we can do a whole encyclopedia on that. And Ms. Gray, when this first happened, this was, you weren't even involved in this. But then to come out, this was an executive session. Whether we agreed with it or not, it was an executive session. And it was wrong for it to get in the newspaper less than 24 hours after the meeting. And yes, she said councilman. So only Ms. Dorn, I guess, and God knows, and he ain't telling. So there's been a call for the question, and my understanding is to vote on the call for the question, correct? Okay. Roll call.
I'm sorry, who called the question?
Okay.
Goodman? Okay. Call on the question. Fiorelli.
Aye.
Gelfand.
Aye.
Goodman. Gray.
Nay.
Ico.
Nay.
Romeo.
Aye.
Miller.
Aye.
5 ayes, 2 nays.